We now move into a form that applies only to certain Arizona properties, but carries extremely serious contractual and regulatory consequences when it does apply. The on-site wastewater treatment facility addendum is required whenever a property is served by a septic system or alternative wastewater treatment system rather than a municipal sewer connection. Unlike many addenda that simply allocate risk between buyer and seller, this form exists because Arizona law and Arizona Department of Environmental Quality, ADEQ, regulations mandate inspection and transfer procedures prior to ownership transfer. This means the requirement is regulatory compliance first and contract negotiation second. Failure to properly complete this addendum can delay closing, prevent recording, or expose parties and brokers to liability. Why this addendum exists. ADEQ regulatory requirement. Arizona properties located outside municipal sewer service areas commonly rely on conventional septic systems or alternative on-site wastewater treatment facilities. ADEQ rules require verification that these systems are functioning properly before ownership transfers. The purpose is public health protection, groundwater preservation, and environmental safety. Buyers must not unknowingly inherit failing wastewater systems that could create contamination or costly repairs. Therefore, Arizona requires a pre-transfer inspection completed by a qualified inspector recognized by the applicable governmental authority. Brokers must recognize that this is not optional when a septic system exists. Arizona example: rural property near Payson. A buyer purchases a home on acreage outside city sewer service. The property operates on a conventional septic system installed years earlier. Before closing, the seller must obtain an ADEQ-recognized inspection, verifying whether the system is functional, functional with concerns, or not functional. Without this inspection, escrow cannot properly complete the transfer requirements. Even if both parties agree to waive inspections, ADEQ transfer rules still apply. Seller inspection responsibility, timing requirements. The addendum requires the seller to complete the septic inspection at seller's expense within 6 months prior to close of escrow, and typically within 20 days after contract acceptance unless otherwise negotiated. Timing matters because inspections older than 6 months become invalid for transfer purposes. This requirement frequently affects delayed escrows or extended construction timelines. Brokers must monitor inspection dates carefully to avoid last-minute compliance failures. Conventional septic pumping requirement. If the system includes a septic tank, pumping is generally required prior to closing to remove accumulated waste. This ensures inspectors can properly evaluate system condition and verify operational capacity. However, pumping may not be required under limited circumstances, such as recently issued discharge authorization, manufacturer maintenance standards indicating pumping is unnecessary, or confirmation that no waste accumulation exists. Agents should never assume pumping exemptions without written verification from qualified professionals. Document delivery protecting buyer investigation rights. Within the contractual time frame, the seller must deliver facility documents to the buyer, including the completed inspection report and any available permits, maintenance records, or operational documentation. These records allow buyers to understand long-term maintenance obligations and system lifespan expectations. Missing documentation is common in older Arizona properties, especially rural homes transferred multiple times without proper record retention. Buyers should be encouraged to review these documents carefully during the inspection period. Inspection results. Functional versus not functional. The inspection outcome directly impacts contractual rights. If the system is determined to be not functional or cannot be certified, the seller must repair the system up to an agreed financial limit, commonly 1% of the purchase price unless another amount is negotiated. If repair costs exceed that limit, the buyer may cancel the contract or negotiate payment responsibility. Alternatively, the seller may cancel unless the buyer agrees to assume excess repair costs. This structure balances environmental compliance with contractual fairness between parties. Arizona, example repair negotiation scenario. A property in Casa Grande sells for $400,000. The septic inspection identifies system failure requiring $9,000 in repairs. The contract limits seller repair obligation to 1% of purchase price, or $4,000. Buyer may cancel the contract, renegotiate terms, or agree to pay remaining repair costs. Without this addendum clearly defining responsibilities, disputes commonly arise during escrow. Functional with concerns. Understanding risk allocation. If the system is classified as functional with concerns, neither party is automatically obligated to perform repairs. Instead, the parties may negotiate improvements voluntarily. Buyers must understand they are accepting operational risk moving forward if no repairs are negotiated. Brokers should strongly recommend professional consultation because septic replacement costs in Arizona can exceed $20,000 to $40,000 depending on soil conditions and system type, buyer disapproval, and cancellation rights. The addendum preserves buyer protection by allowing cancellation within the inspection period or within 5 days after receipt of facility documents, whichever occurs later. If buyer does not deliver written cancellation within that time frame, the buyer is deemed to accept the system condition. This automatic acceptance provision makes timeline tracking critical for Arizona licensees exercising reasonable care under AAC R428-1101, Notice of Transfer Mandatory Filing Requirement. Arizona law requires submission of the ADEC Notice of Transfer of Ownership form prior to closing. Escrow is instructed to file this document along with applicable transfer fees at close of escrow. Without this filing, ADEC records will not reflect ownership change, potentially creating compliance issues for the new owner. Responsibility for payment of transfer fees must be negotiated between buyer and seller and clearly indicated in the addendum. Broker risk management and supervision responsibility. Under AAC R428-1103 broker supervision rules, designated brokers must ensure agents recognize when septic addenda apply. Many compliance complaints arise when agents fail to identify properties served by on-site wastewater systems early in the transaction. Best practice includes verifying sewer versus septic status during listing intake and buyer consultation stages rather than discovering the issue late in escrow. Arizona real-world broker scenario. A new construction home installed a septic system 1 year prior but was never occupied. Agents sometimes assume inspection requirements do not apply because the system is new. ADEQ rules still require a valid inspection within 6 months of transfer unless qualifying discharge authorization exceptions apply. Understanding this distinction prevents closing delays, a situation many Arizona brokers encounter regularly. Discussion question: can buyer and seller agree to skip the septic inspection requirement? Answer: no. ADEC regulations require inspection prior to transfer when an on-site wastewater system exists, regardless of contractual waiver language. Discussion. Question: who typically pays for the septic inspection under this addendum? Answer: the seller pays for inspection and pumping unless negotiated otherwise in writing. Discussion. Question: what happens if buyer fails to cancel within the allowed time frame after receiving septic documents? Answer: buyer is deemed to have accepted the system condition and proceeds without required repairs.